Hello and welcome to the Arbitration Conversation. So in this webisode, we're going to talk to another leader and scholar in the world of arbitration who I've actually known since I first started teaching. And I can remember way back many years ago, it seems like a zillion years ago, but I'm guessing like 21 years ago, probably at an American Bar Association meeting, speaking on a panel about arbitration with this guest. So our guest today is Stephen Ware. Stephen Ware, he is a law professor, actually has a very good title, I must say. He is the Frank Edwards Tyler Distinguished Professor of Law at the University of Kansas, of course, which is our neighbor to the west. And he teaches ADR, bankruptcy, contracts, and commercial law, specifically secured transactions. What we're going to talk about today is his many books. In fact, he has a brand new book out, a case book on arbitration, but he has also produced a shorter horn book as well as a more elaborate horn book, and he has a book with Cambridge University Press examining arbitration. So, hey, thanks for being here, Stephen.
Thank you, Amy. It's great to be with you. And you're right. We go back a long way. We've had a lot of fun with arbitration over the years, and 2020 needs some fun. So it's nice for me to have something fun to talk about.
Well, this is great. So I want to kind of dive in and hear a little bit about, because, you know, we always get these case books. They come out, they come and they kind of sit on the shelf, or you assign them and the students use them. But I always wonder, you know, and actually I'm part of a group on a case book that I'm working on as well. So I understand kind of the thought process. I'd love to hear what your thought process is. You know, as you think about is it just about dumping a bunch of cases in and putting it on the shelf? Or give us a little bit of your kind of, are you a chef? How do you put it together? And how do you think about the pedagogy behind it?
That's a great question, because that's exactly where I was starting this book, which is I have been doing, as you know, arbitration for well over 20 years, and had always known that it was fun in the kind of intellectually interesting way, but I never had the opportunity until this casebook, which, by the way, I will hold up because it's a fun color. It's orange.
Love it.
Orange casebook made me appreciate how fun arbitration can be when you look beyond law, interesting legal issues, till you look to the big picture of the people, of who is doing arbitration and who is agreeing to arbitrate, parties to arbitration agreements. So some of what I got into was just sort of the fun of celebrities, getting into Justin Bieber and Kylie Jenner and Jay-Z and Super Bowl football issues and whatever. So some of it is just like celebrity kind of fun. But even there, it raises bigger issues that are fun, like Jay-Z on racial diversity, lack of African-American arbitrators. That's an interesting, important issue. And to be able to do a case book where you get the fun entree into an issue like that of, oh, here's Jay-Z, he's a celeb, he's important, he's in the news. Same with President Trump and Stormy Daniels, right? I mean, that's a sort of scandalous front page kind of news thing.
100%.
But it gets to the deeper confidentiality, secrecy side of arbitration. So it's just great fun.
Well, and then here's the thing, and you know, I'm always going to challenge you, right? Because that's what we do. We debate things. So I do have to ask you, you know, how do you, and I agree, we all want fun, right? But we also got to get down to the work of teaching the very kind of really fun, mentally, there's a lot of analysis and kind of this, how do you look at, it's really, you know, complex contract law coupled with this Federal Arbitration Act, state arbitration law, Constitution, all the rest of it. So how do you take these really cool, kind of sexy topics and fold them into the analysis and organization of a casebook?
Yeah, that's a really good practical challenge of writing the book and thinking through a syllabus, thinking through a course where you want it to work for a variety of teachers. You want it to work for teachers who have a short amount of time period versus more hours, more credits to work. And you want a casebook to work for teachers who have different emphases, maybe depending on the curriculum in that school, what this particular course has to work for. And so arbitration courses, sometimes you see them really focused on labor arbitration. Sometimes you see them really focused on international arbitration. And I really thought the fun thing is to write the casebook that can be flexible, that can do it for whichever kind of course that teacher wants to have. So I've got a model syllabus in the book that says, if you want to do the sort of plain vanilla, cover everything, but not go too deeply into anything, here's the way you can do it. On the other hand, if you have particular interest in the international side or the labor side, then here's a different way you can emphasize the material. And your point about contract law, you and I both talk about contracts sometimes, that's a great framework for an arbitration course in the sense that students are familiar with it and it has an ease to it that comes with familiarity. So you can start chronologically, parties forming agreements. Is it going to be enforceable? Then get into, okay, now parties are actually going to arbitration. What's going to happen there? And then, oh, if there's a dispute afterwards about what happened in arbitration, is the award enforceable in court, et cetera. So a chronological contract kind of framework seems to work for a lot of students and teachers.
Oh, 100%. You know, I'd love to take kind of one example and get your thoughts on how you wove it into the casebook. So for example, with the Justin Bieber and sort of arbitration, how do you, first of all, could you tell the listeners, watchers, what happened? What does Justin Bieber have to do with arbitration? And then secondly, how do you weave that into the book?
So what's cool about this Justin Bieber story is the international side of it, where people may know he's Canadian. And if he's planning to do Kylie Jenner's birthday party, he's going to perform there in the US, right? So you end up having a Canadian court staying litigation in Canada and ordering arbitration in California in the US. So the international side of, oh yeah, you know, this works across borders. And that's huge because one big advantage of arbitration over litigation is how arbitration can deal with borders in a smoother way than litigation, particularly at the enforcement stage of if you win a judgment in a foreign court, trying to get that judgment enforced versus if you win a foreign judgment in arbitration, trying to get that enforced.
That's a really great, I love that. I mean, because that is really interesting. I don't think people would, you know, so, and of course you're bringing in the New York Convention. So you get a chance to sort of introduce treaty law and how that intersects with arbitration law. Again, this is, I mean, you're speaking of the choir, of course. I think arbitration is really fun, but let's think of some other examples. So how do you work in the Trump situation and Stormy Daniels? How do you kind of work that into the casebook?
Well, that's the confidentiality or secrecy side of it. I mean, clearly you've got deeper issues about what enforcement courts are going to do about agreements to arbitrate that one party does not want to arbitrate. And then to what extent are parties going to be able to or required to keep secret or confidential either what happens in the arbitration or even the fact of the arbitration agreement in the first place. So NDAs, non-disclosure agreements, very controversial for good reason nowadays. And they intersect with arbitration agreements where they're separate things, but how they work together is a really kind of contemporary, important, interesting issue.
Oh, 100%. I love that because it brings us back, you know, again, kind of reminiscing, but there was that symposium at KU on arbitration many years ago. I don't even remember what year that was. And that's what I wrote about. My piece was actually about the difference between privacy and confidentiality, which is something that often is kind of overlooked. So bringing in the sort of NDA aspect of arbitration, because arbitration isn't necessarily confidential unless you have this kind of a non-disclosure agreement.
Yeah, you really were early ahead of the importance of that issue, and you're still right that these two things can be combined, but don't have to be combined.
Right, right. So let me ask you also, kind of looking at, and now, having written these Horn books and also now with the case book, what do you do with kind of the evolution? How do you sort of address the evolution of the jurisprudence around the Federal Arbitration Act? Because as you and I both know, it has changed fundamentally from when we both started teaching.
Yeah, and to me, the fun of that is to see the politics, particularly on the Supreme Court, change over time, and then ultimately politics in Congress. In the sense, you and I maybe were sort of formed in arbitration law in the 1990s, and back then, Supreme Court didn't have the kind of clear on arbitration liberal conservative split it has now. Back then, there were conservative justices who had a sort of federalism concern with state arbitration law not being entirely preempted by federal arbitration law. So you had interesting sort of mishmash of normally liberal, normally conservative judges sort of teaming up on opposite sides of cases. And then, as you well know, in more recent years, we've seen a sort of more predictable, often 5-4, predictable ideological split on the Supreme Court. But what the Casebook Project got me to realize about that is the era that we came about in all this in the 1990s, that was the aberration. And that if you go back earlier to the 80s and even all the way back to Wilco versus Swan in the 50s, it really does trace back to FDR and Harry Truman, the New Deal Democrats, who appointed the Supreme Court that decided Wilco versus Swan and said, no, we're not going to enforce arbitration agreements with respect to securities claim. That really is the presidents who presided over the Great Depression and the response in the federal securities laws and the rest of that New Deal sort of growth of government and regulation, saying we don't want arbitration agreements, privatizing contract to weaken the enforcement of those federal statutes. And you had conservatives dissenting. And then in the Reagan era, you see it flip, right? Then in the 80s, you see that more conservative Reagan era justices overruling Wilco versus Swan and enforcing arbitration agreements to send more statutory claims to arbitration. So I didn't realize how political in the big ideological sense that earlier history was.
Yeah.
Until
I mean, that's super. I love that. I mean, it's really interesting because if we even want to go back further and thinking about sort of its underpinnings, I mean, what I think is really fascinating is thinking about 1925, right? And thinking about the fact that the Federal Arbitration Act, the people who built it, never imagined employment or consumer or some of these different areas of arbitration. It was really meant to be a business-to-business commercial type arrangement. We even had the New York Chamber of Commerce behind the original Federal Arbitration Act. So watching the evolution, I would say, is in and of itself just tremendously interesting.
And that interest is so great for a course like arbitration that a lot of students take relatively late in their law school careers, where they've already taken some other areas of law and they're able to tie things together in the sense of, oh yeah, I learned a little something about labor law, and I see how there's a little bit of a clash now when the Federal Arbitration Act and labor law are coming together. And and the point that you made about consumer law brings in huge constitutional point of the Commerce Clause expanding during the New Deal, things that people previously thought were intrastate, now we have to interpret the Federal Arbitration Act in light of this new, bigger constitutional structure where more things affect interstate commerce. So it's a great way to see how arbitration law is connected with so many other areas of law.
Oh, that's a great way. We're kind of short on time because that's a great way to kind of bring it all together, because what I will say is fantastic. I think your book is wonderful. I'm looking forward to seeing more and learning more about what you've been doing. And I have to say, like, I'm with you, man. Arbitration is a fantastic course, and I hope that any students who check out this video will make sure to sign up, because it brings together so many different areas of law and really helps you to see how they interact and brings analysis to a whole new level. So thank you for thinking about these things. Thank you for creating wonderful scholarship in this area. I really appreciate it.
All the same, right back at you, Amy. Thank you. Great fun talking with you as always.
Enjoy yourself. Enjoy Kansas. Of course, when we play you in football and basketball, Mizzou will win.
Bye-bye.